So, guys, we're going to go over FCRA, your rights under the FCRA, okay? Starting out, I want to say something about these rights. These rights in isolation don't mean much, okay? So somebody can say, you know, you can't do X. All right, well, what if I do it? What if I do it? What are you going to do? Okay? And so the FCRA, one thing that we've got to be thinking about from the very beginning is we've got a right. How do you enforce that right? What do you do to protect that right? Because that right, just having the right by itself, doesn't necessarily mean a lot. And in fact, we've seen exactly how much, how important it is to protect these rights, because we've seen an aggressively increased aggressive stance against protection of these rights by not only the CRAs, but unfortunately by the federal court system, who continues to remove and erode rights that exist, that are in the law, but it's not enforceable unless you plead specific damages in a certain way, or you, state specific harm with specificity. Unless these things happen, well, then you've got a right, sure, but you can't do anything about it if you suffer a violation of that right. So from the get-go, we gotta not only think about rights, but how to protect those rights. That is the most important aspect of having that right, is protecting the right. Okay? Because again, your rights will go away very, very quickly if you do not follow specific steps, especially with regard to navigating the intricacies of federal law. So, right number one, you have the right to be informed if your information in your credit report is being used against you in some way. So typically the way that this will happen is in regard to an adverse action letter. Okay, we'll say, hey, look, we looked at your information in your Experian credit report with regard to you applying for this car loan, and your information was used against you to deny you for this because it turned out that your credit score wasn't sufficient. So they will provide some information about the reason behind your rejection, okay? Adverse action letter, negative info used against you, you have the right to an adverse action letter. Now, in terms of preserving this right, I'm not sure you have to do that much actually to preserve this right. This is something where, you have to act within a certain period of time to preserve your right. But there's not too many additional steps that need to take place in order to protect your rights for the negative info. Okay. Second deal, you have the right to request a report every year. Well, preservation of this right is very easy, because all you need to do is make your request, okay? So if you want a report, you've got the right to one. In order to enforce that right, simply request a report. The CRAs, somewhat with a gun to their head by the federal government, set up a website, it's Annual Credit Report. Okay, annualcreditreport.com. That is not a government website. That is a website set up by the industry to make it easier for them to provide you with your credit report. You can also request the credit report directly from the CRAs. I haven't been on this recently, but I will say that I'm not sure if all the CRAs are on there, if it's just the big three. It may have just been set up by the big three. I'd have to go back and look at that. I simply don't use that because it also doesn't provide users a score on that annual credit report. It's very limited in the information, but for the general consumer who's interested, hey, I don't want to pay for anything and I want to know what's on my credit report, this is a great resource. This is a great resource for that individual. We typically will utilize third-party resources simply because we need additional information, and our clients are typically interested in scores and improving those scores and have a desire to participate in the credit system beyond just kind of knowing what their information is at. So with regard to annualcreditreport.com, we use a product at MLA, Identity IQ. They've been very supportive of our organization, and we've got a good thing with them. But it's important to look at the marketplace as a whole and get it from the place, your credit report from the place that you feel most comfortable. Yeah, there needs to not be a ton more said about this. Simply, if you want that report, go ahead and request that report. This is one tool available. Identity IQ is another tool available. You can also go on a variety of Triburo, excuse me. I think it's idiq.com. Okay, at any rate, restrict users. This is another right that people have under the FCRA. You have the right to restrict who sees your credit report, and you can do that in a couple of different ways. One, you can restrict who uses your credit report for pre-screened credit offers. So you can actually, in order to utilize this right, you send a letter to the CRA and you say, hey, look, I don't want my information being provided for marketing purposes. Pre-screened offers, I don't want the junk mail, okay? That is a right that you simply preserve by utilizing it, okay? And if indeed they don't abide by that, I'm sure you can take additional action. I've actually never brought a case with regard to something like that, but I would be ill-advised to give you more detail on that simply because I've not done that. Another way that you can restrict users, or that the law itself restricts users, is they limitations on who can access credit reports just by operation of law. Specifically, they say, hey, look, you need to have a permissible purpose to go access a credit report. You can't just be like, hey, I want a credit report on Tommy over here, and therefore I'm just going to go pull his credit report. You can't do that. You need a business purpose. You need to certify to the CRAs that you're actually doing it for a legitimate reason. We recently sued a company, mylife.com, which was collecting consumer information and selling to anybody for a simple fee. So we were actively in litigation with them that actually just passed a motion to dismiss, got a very favorable ruling, and we intend to take them to the mats on that. Preserving this right to restrict who sees consumer information. Keep in mind that the FCRA, when it was enacted, was fundamentally a privacy rights. I mean, that was the background to the FCRA. Certainly, our modern incarnation of it, we are familiar with the disputes, and we'll go into that in a second. But when it was enacted, this was really focused on privacy, on making sure that people's information, the more and more information about people that got collected, that was dealt with in a responsible manner. So, restrict users, we've got that. Inaccurate information, you have the right to have a fair and accurate credit report, okay? And the CRAs have responsibilities under federal law to assure that their information assures maximum possible accuracy when they assemble that report, okay? And in the event that they don't do this is a rarer event than what we'll discuss here in a second, which is just disputes generally, but in the event that the CRA assembles a report and doesn't have a policy or procedure in place to assure maximum possible accuracy, that requires very little in order to preserve your right. You certainly have to act promptly, act within the statute of limitations. We have a video discussing the statute of limitations and the statute of repose and how those things interact. I'd encourage you to look at that video. Suffice it to say, it's roughly 2 years. So you do have to act promptly. But you can really bring your case in the event that you identify something where there is no policy or procedure in place. And I'll give you an example of this. So recently we brought a case whereby TransUnion and Equifax were reporting an individual who was an authorized user on a credit card, an authorized user in distinction from somebody who is a co-signer. An authorized user has no financial responsibility for the account, and I can make anybody an authorized user simply by giving their name to my credit card company and saying, hey, send me a credit card with this person's name on it. I agree to be responsible for the account. So would it make a lot of sense for that information to end up on a credit report? And in fact, if that information on a credit report of the authorized user. And if that information did end up on the credit report of an authorized user, our argument was, hey, this is at the very least misleading. It may not be accurate. It may be accurate that that person's an authorized user because I made them one, but they might not know about it. They may have never used it, and putting that on their credit report would be fundamentally misleading. That person doesn't even know that account exists, okay? So that would be kind of an example. And if the CRA did not have policies or procedures to guard against that, you might have an inaccurate information or a failure to maintain reasonable procedures to assure maximum possible accuracy claim. So that would be kind of that bailiwick, and then what holds everything within that box. But the more important thing, the thing that we really interact with in today's society is the dispute process, okay? Much more, I would argue, than the 1970s when this statute was enacted. The disputes and credit as a whole is now affecting us down to getting a telephone, right? Before you pay cash for your telephone, I'm sure. I guess I wasn't alive in the 1970s, so I don't know. But I assume you just you got the bill, and when the bill came, you paid it, and if you didn't pay it, the telephone got cut off, right? But now we apply for these, $800 iPhones or $1,200 iPhones, and you don't typically pay for that up front. You utilize credit to get access to the phone. You certainly utilize credit for student loans, for, college was a lot cheaper before, right? For student loans, for your first car, for a house, jobs. You will sometimes run credit reports for people. So this issue of credit is far more important to us, I would argue, in today's society than it was in the 1970s. So sometimes we forget the FCRA was a privacy statute, but today, it's really the statute that protects our rights to engage in the American economy, right? And so today's perspective is right here, and this right here requires a specific process. And if you do not follow a specific process, you will destroy your right here. You will lose your rights, okay? You will not be able to bring a lawsuit under the FCRA, okay? And one other quick thing I'll say about this is the FCRA generally, it gave us a lot of rights, right? But it also took something away. It took away the right to litigate cases under state law. It took away the simple idea that if somebody posts something about me that's negative and it lowers my standing in the community, I can bring a defamation suit. I can bring a lawsuit under state law. It's called defamation. It's the same as if Tommy called me a criminal, from the rooftop, okay? I could sue Tommy for defamation, although, he might be right, although I don't think I'm a criminal. So there you go. So it took away this right? And so now you can't just bring a simple defamation suit. So you can't do that. So now you're really reliant on this dispute process, okay? So let's go into this real quick. What has to be done? The letter, in order to preserve your right under your rights under the FCRA and your rights to damages and statutory attorney's fees and statutory fees and all that other all those other great elements of the FCRA. In order to preserve that, your dispute letter has to go to the CRA. It cannot go to the furnisher of the information. And I'll go back to this idea that it's very natural for somebody to say, hey, Wells Fargo posted some negative information about me on my credit report. I should contact Wells Fargo and try to sort it out. In the event that you send your letter to Wells Fargo and you fail to send your letter to the CRA, you will not have your right to those damages under the FCRA. You will not have your right to enforce your dispute mechanism rights because you will have sent your letter to the furnisher of the information and not through the proper process. That's crazy, but that's the law. The law states that letter actually has to go to the CRA, okay, who transmits it down to the furnisher. We'll call them F, which is Wells Fargo in our example. Okay? CRA sends the letter down to Wells Fargo. Wells Fargo will then do an investigation. They will send that information back up to the CRA, who will transmit that information, which inevitably will say, we have verified your information is correct. Sure, it doesn't have your name, address, you never opened the account, doesn't matter, but hey, whatever, we verified it as accurate. I can almost guarantee that's what that letter will say, because we see it all the time. But nonetheless, that this is the process, and this will entitle you to take some action under the FCRA. But even then, you might not have a lawsuit. Why? Because you got to have damages. When I talk about federal courts eroding your rights under federal law, you can go through this whole process, spend this time, effort, and everything, and if you say, hey, look, I did all this and it's still inaccurate, the court might say, well, you don't have a lawsuit because you haven't suffered any damages. You haven't applied for credit. You haven't applied for credit, therefore you've never been denied. If you've never been denied, you haven't suffered any damages. That is so convoluted and insane. It's difficult for me to even tell you that that's the law, but that's the law. Okay, so we say and this is the case that kind of laid this out from a consumer perspective was Spokio, and this gentleman sued Spokio, which was arguably a consumer reporting agency. It was for the purposes of the lawsuit, and the guy said, hey, look, you posted all this false information about me, it's got my wrong address, whatever information it was, and he said, hey, look, and under the law, because you didn't assure maximum possible accuracy, right, you didn't correct the information after my dispute, whatever it was, I'm entitled to my $1,000 under federal law, which the law is very clear. It says if you have a willful violation of this act, and willful is defined as reckless or intentional, you have a violation of the act, you're entitled to $1,000 or up to $1,000 statutory damages. So he said, I just want my statutory damages. And the court said, well, you know what? Sure, this information was inaccurate, but it didn't actually harm you. And because it didn't actually harm you, despite their blatant violation of federal law, you can't actually bring a lawsuit. And that Spokio has been used, that case, that's a Supreme Court case, has been used time and time and time again in these FCRA suits to say, hey, look, consumer, you had this negative information. This is certainly inaccurate, but it resided in our little credit file, and because you were smart enough to decide to not apply for credit because you knew this information was in there, we're going to hold this against you, and we're going to say you have no damages, and as a result of that, you are going to not be able to bring a lawsuit. So, what is my point of this? You don't need to be an expert in Spokio. You don't need to be an expert in the process for dispute, but I would encourage you to rely on an expert. Come in, stop and talk to a consumer lawyer. Talk to, I hate to push people towards credit repair agencies, but hey, look, sometimes they've got good information. They've at least engaged in the process. I would encourage you to not just send dispute letters that are just trying to get valid information off, and you're just trying to send letters to these CRAs to just overwhelm them. That's totally not the way that the law was written, and I assure you that you will not preserve your rights under the FCRA by doing that kind of crap. But nonetheless, where inaccurate information exists, you could at least maybe use somebody who engages in that process as a resource to at least get some information. I'd encourage you to send the dispute yourself, or go to an organization which engages in legitimate disputes, that doesn't frivolously dispute perfectly valid information, that focuses their disputes on things that are actually inaccurate or inappropriate or misleading under the law. Finally, so again, this is the area that will cause headaches, and this is the area which is, if not done correctly, will cause you to lose your rights under federal law. And by the way, you will not be able to bring that state law defamation claim as your backup, because guess what? That got preempted by federal law. Again, the FCRA here, federal law. All right, law, and that trumps state law. All right. Not in all cases, but we're preempted, and this FCRA specifically preempted state law with regard to defamation. Okay, so final thing that we haven't talked about is the security freeze. If If you're the victim of identity theft, or you're an active, you're a member in the active duty military. I was an officer in the Air Force for a year, for several years, excuse me. I utilized the security freeze process upon getting deployment orders. Identity theft, deployment orders, good reasons to utilize the security freeze, and that is, a law that, a right that you would access simply by activating it, right? By telling them. And again, if they were not to put a security freeze on, I'm sure that there would, you could take some action under the law, but I have not seen that case arise. So that concludes the rights under the FCRA, the key rights under the FCRA. Just to recap, the 30 seconds here, the big thing that we're going to see, in rights preservation here is the dispute process. Talk to a professional, make sure it's done correctly. Read the law, whatever your way of learning is, make sure that you do it and you do it right, because if you do not do it right, you will have problems when inevitably you get that letter back from the CRA that says, hey, we validated this information as accurate. Okay? When you get that back, you want to be able to do something about that. And if you don't follow the proper process, then you will not be able to do something about it. And that will cause, you may be able to do something, but you won't be able to do something in the format which will benefit you the most. So it is of critical importance that you talk to a professional, or you read the law, or again, however you learn, to make sure that you're doing this right. Don't screw this up, do it right. Preserve your rights as a consumer, preserve your rights as a member in our economic system, and improve your standing, your income, and your ability to participate in the economic system by knowing your rights under the FCRA. That is incredibly important. And I would encourage you all to both read the law and come consult with us. Again, I'm here from Minnesota Legal Assistance. We are in the business of helping consumers to understand their rights. We are in the business of helping consumers navigate this process. We are a 501c3 organization, and it is our goal to help as many people as possible. And that's part of the reason that we do these videos. There are a host of other videos that I encourage you to look at and to review. Take your time and make sure that this is done correctly. Thanks so much for watching.